Ladies and gentlemen, we kindly ask you to please take your seats as we prepare to commence.
Por favor, solicitamos a todos los asistentes que vayan tomando sus asientos.
Working yet? Yes, there we are. Okay. Okay, so we need all these lunch people to come back in. This is when you're innovating, you have the valley of death. This is the panel of death, where everybody's having lunch, half asleep, and it's the most important topic. Is there anybody out there still in the lunch area? No? Okay. So they've gone on a good leisurely lunch. All right, welcome back everybody, or most of everybody, or about 3/4 of everybody. We continue. I hope you had a good lunch. Just like to bring you back to the theme. Justice as a cornerstone, resilient societies, and thriving economy. And that's what we're going to look at now, the thriving economy. And if there's one thing that I've learned in my conversations with politicians on justice, is that they could be a bit cynical if you say justice is good for people. But if you say it's good for business, they kind of sit up. It helps. So this is really important. How can, in this fast-changing world, justice help businesses, and in particular, I think the SMEs of the world, operate with confidence, have legal certainty, etc., etc. We have a panel with 6 leading experts, which I will not introduce to you. That will be done by the moderator, who I will now give the floor, Francisco Ortega, the president of AMETIC.
Thank you very much. I will ask my colleagues in this roundtable to join me. So please, Ana Gallego Torres, Anda Smith-Lena, Midori Watanabe, and Udo Judlio. Please join me in this roundtable. Okay, thank you very much. I will introduce them very shortly. You have it already there on the screen, but I think it's worth to spend a few seconds introducing them. Ana Gallego Torres is the Director General for Justice and Consumer, European Commission. Anda Smith-Lena is Deputy State Secretary of Law Policy from the Ministry of Justice in the Republic of Latvia. Midori Watanabe, afternoon, Attorney of the Civil Affairs Bureau from the Ministry of Justice of Japan, and Udo Judlio is Chief Executive Officer from the Hague Institute for Innovation of Law. Thank you very much for joining us. Also, will be on the screen later on in a few seconds, Felix Stefek, that is the Professor of Law from the University of Cambridge. Thank you very much for joining us in this very important and very great roundtable talking about justice for growth and competitiveness, as it has been just introduced. These sessions aims to explore how tailored justice services can strengthen economic competitiveness and support businesses, particularly small and medium enterprise. Bringing together perspective from the legal and business community, we will examine how legal certainty, effective enforcement, and simplified procedures are critical for small and medium enterprise ability to resolve their justice problem effectively and fairly, reducing productivity loss and, more important, improving business outcomes. This session also will highlight how innovative approaches, including targeted dispute resolution, legal capability building, and digitalization, can ease burdens on small and medium enterprise to unlock the potential for growth. So, as was mentioned before, this is a very important roundtable about justice and competitiveness, especially in the small and medium enterprise. And before giving you the floor, I would like to introduce, as I said, Felix Stefek, Professor of Law of University of Cambridge. He could not join us today here, but we have a short video from him, and please, if it is possible, we would like to hear and to listen the speech from Felix Stefek. We can give an applause to Felix.
It is a great pleasure presenting the new OECD policy paper on supporting businesses to better justice systems. The paper focuses on SMEs and entrepreneurship. My name is Felix Stefek. I'm a professor of law at the University of Cambridge and one of the contributors to this paper. What are the key findings of the paper? The paper first engages with the systematic disadvantages that SMEs face. They all too often lack the legal and financial resources to manage their disputes effectively. All too often, justice systems cater to larger firms. The effect of this is that procedures are inefficient and too costly for SMEs. This then leads to a mismatch between the justice problems of SMEs and the services available, showing in the form of high litigation costs, lengthier proceedings, regulatory burdens, and poor information availability. It also shows in the fact that SMEs make limited use of alternative dispute resolution and online dispute resolution. The impacts and economic consequences of these gaps are undesirable. The unresolved legal needs and justice problems result in financial losses, even business closures, and at a macro level, in reduced competitiveness. Such SMEs are particularly vulnerable during periods of economic crises. Specific groups are often even more affected. This concerns micro-enterprises, startups, and women-led businesses. Against this background, the policy paper engages with the issue of data collection and recommends targeted legal needs surveys and collecting data at the service level, i.e., at the level where disputes are solved. Against this background, the report makes a number of recommendations. It recommends adopting a user-centered approach to justice. This means designing legal and dispute resolution services around the needs of SMEs and not starting at the institutional level. One way could be to introduce a code of dispute resolution for businesses. This would help to establish fair and standardized legal principles that benefit SMEs. Also, alternative dispute resolution mechanisms could be expanded. This concerns mediation, arbitration, but also online dispute resolution. Such mechanisms could be promoted via awareness campaigns. Regulatory proposals could help integrating such mechanisms into digital dispute resolution platforms. This could be part of a larger effort to simplify legal procedures and justice services. Also, SME-focused legal aid programs would be worth a consideration. All in all, then, this could be a development towards investing in a digital justice infrastructure. Once such dispute resolution mechanisms, in particular online dispute resolution mechanisms, have been developed, they can be promoted via e-platforms, e-residency programs, digital business registries, and automated compliance tools. Keeping in mind that there are SMEs with specific needs, the report recommends inclusive reform, meaning targeted support for vulnerable groups, including women-led and minority-owned SMEs. This can be implemented via evaluations of legal and regulatory reform through an SME lens, ensuring that policies do not unintentionally disadvantage smaller businesses. Thank you very much for engaging with this new policy paper. I hope you find it interesting.
Thank you very much, Felix. And now then we go here in Madrid with this roundtable. And I think it's one of the most important enterprises that the justice will be something easy for them. No? So one of the things we are going to ask all the members of this roundtable, also from the different views, from the different also position they have in the justice, is what are the most common legal needs and justice problems that you see that a small and medium enterprise face in your country today, and you can give us some examples. Also, how can justice service can be tailored to help justice system to better meet the needs of businesses for these companies, and how innovations have been proven effective or are showing promises in resolving business dispute. This is very important because if we can have some solution and some example, could be useful for the rest of the people that are here today and the people that also that are following on streaming. So thank you very much. Maybe we can start with Midori, if you want, as you have a presentation now.
Thank you. Can I use the presentation material? Thank you. I'm Midori Watanabe, attorney from the Ministry of Justice of Japan. I would like to begin by expressing my sincere gratitude for inviting me to this very important meeting. I'm originally a judge, and I have dealt with civil litigation cases for about 10 years. Now, I'm working as an attorney in the Ministry of Justice of Japan and in charge of the international matters regarding civil affairs. Today, I'll be going over the efforts to make more efficient and accessible justice services for businesses in Japan. I will cover 3 issues: digitalization of civil litigation, promotion of international ADR, and efforts in developing international rules. Next slide, please. Can I use? Thank you.
Thank you.
First, I would like to share the information about digitalization of civil litigation. The amendment to the Civil Procedure Code was enacted in May 2020, and this achieved full digitalization of the civil litigation procedures in Japan. The key components of the amendment are e-filing, e-case management, and e-court. This amendment enables online filing and submission and online hearing. In addition, case records are digitalized. This digitalization enhances convenience for business litigant parties and their representatives. It reduces costs for attending a hearing and printing, mailing, and managing documents. Also, it enhances convenience for sharing information within organizations. In addition, the amendment established a system to set a time limit for the court proceedings in a certain case. Under this system, with the consent of both parties, a trial is concluded within 6 months of the commencement of proceedings in certain cases, and a judgment is rendered within 1 month thereafter. These amendments reduce litigation costs for businesses, enable more speedy and efficient hearings, and enhance predictability of proceedings duration. For businesses, as the promptness of concluding transactions and decision-making become more important than ever, swift and legitimate settlement of dispute is essential. Judicial sectors are also making efforts to meet such expectations of businesses. For example, in some corporate litigation cases, the judges and the parties are taking advantage of the functions of the web conference platform, including the chat function and the screen share function, to discuss the issues in dispute and present arguments. As the judges listen to the parties' arguments and engage in the discussion with the parties, such functions facilitate the performance of the judge's case management responsibilities by identifying the key disputed issues and compiling a list of the main arguments presented by both sides on the spot. The judges could share the list of issues and arguments with the parties, and the list serves as a good basis in further narrowing down and clarifying the disputed issues through communication amongst the judges and the parties. Multifaceted communication and increased transparency of the communication amongst the judges and the parties assist the judges greatly in identifying the core issues in dispute at an early stage. Enhanced communication will also serve to encourage parties to reach settlement agreements, which will further lead to increasing the trust of the judicial system. This is only one such example of a novel method adapted in court proceedings by using technological means, but it does seem to demonstrate the potentials of digitalization further strengthening the delivery of justice. Furthermore, so-called business court started its operation in 2022 in the Tokyo District Court. Divisions dealing with business-related cases, such as commercial cases, intellectual property cases, and insolvency cases, operate together in the modern business court building. The consolidation of business-related cases into the business court makes it possible for judges to deal with cases more speedily and justly. Secondly, I will share Japanese efforts to promote the international ADR. Arbitration is an effective and trustable way of resolving international disputes for businesses. As a means of dispute resolution regarding cross-border transactions, international arbitration is now the global standard. As such, the Japanese government has undertaken various activities such as the promotion of international arbitration and mediation. Aiming to harmonize the international standards, Japan amended its Arbitration Act in April 2023, making it more consistent with the ancestral model law. The amendment contains renewed provisions for interim measures, relaxing requirements in arbitration agreements and submission of translations, and extending the jurisdiction of courts in Tokyo and Osaka to arbitration-related applications. This enables access to high-quality dispute resolution services. In addition, Japan became the 12th state party to the Singapore Convention on Mediation in 2023. In preparation for ratifying the Singapore Convention, Japan enacted the Implementation Act for the Singapore Convention on Mediation in April 2023. This act came into force in April 2024. This act provides an effective mechanism for the enforcement of international settlement agreements resulting from mediation. We believe this mechanism further promotes the use of international mediation as a means of international commercial dispute resolution. Furthermore, the Japanese government, in cooperation with relevant organizations within and outside Japan, has undertaken various activities such as the promotion of international arbitration, education and capacity building for law school students and young practitioners. Finally, I'll talk about Japanese efforts in developing international rules. The Ministry of Justice actively contributes to the development and dissemination of international rules in the fields of civil and commercial laws. As part of the efforts, Japan proposed a project to research and analyze issues in the digitalization of dispute resolution practice at the onshore. This project is called DRD project. This project seeks to address the growing impact of digitalization on legal dispute resolution procedures, including international arbitration and mediation. Please take a look at this page. Under the DRD project, these issues were mapped. In July 2024, Japan further proposed the development of international rules to accelerate the digitalization of arbitration proceedings. The proposal was adopted by the Onshore Commission and referred to a working group for further deliberations. The working group is considering a legal framework regarding the electronic arbitral hours and electronic notices now. This activity will be helpful to improve access to dispute resolution procedure in the future. I would like to conclude my presentation here. Thank you very much for your kind attention.
Thank you very much, Midori Watanabe. By the way, after the presentation, you will have also opportunity to ask questions to the speaker. So please prepare your question, and after the first round, we can ask you for your question. I will ask now to ask Anna Smith-Lena, Deputy State Secretary of Law Policy, Ministry of Justice for the Republic of Latvia, to also answer on these three questions we were talking about before, also the view you have and your experience and some examples. Thank you very much.
Yeah. First of all, thank you very much for inviting me here. It is my honor to be here on this stage. But now let's imagine that me and my family, or you and your family, want to open a small family business, let's say a small cafe. And it turns out that starting a small family business like cafe takes far more than just perfecting family recipes. It turns out that before selling our first product, entrepreneurs must navigate some legal, administrative, and compliance requirements. Some examples here, like we have to choose appropriate legal form. And to do that, we must have some kind of knowledge about liabilities and tax regimes, which are kind of legal and administrative questions. We must draft founding documents, prepare the company statutes, and register the enterprise, and we must understand our tax obligations. And a bizarre thing is that I must also have employment contracts with my mother and with my dad and my partner and children, so everybody in my family, because they're going to work here. And I also must draft those contracts. And of course, I must keep workplace safety record keeping and instruct my family on work safety, and only then we can start to work. And it turns out that these are most typical hurdles that small entrepreneurs face when they want to start a small family business. And it's bizarre when you look upon from the perspective of a person that before you start to sell your coffee, you must know everything about tax and everything about labor law and everything, and only then you can start to prepare coffee, yeah? And well, many entrepreneurs are familiar with those concepts. They maybe have seen those contracts and they had, but once you have to do it with your own hand, maybe it's the first time in your life when you do it, And suddenly it's more complicated. And I must admit, I'm a civil servant all my life and a lawyer, and I have drafted a lot of legal acts that require those documents to be prepared. But if I must imagine that I have to start a small coffee shop and I must, let's say, draft a founding documents of company, it would also be for myself the first time in my life when I do it. Yeah. And actually, the small companies, SMEs, are 99% of Latvian economics. And if we talk about workers in private sector, it's like 79% of all people who work in private sector work in SMEs. And so according to the opinion of the companies, what are the biggest hurdles for them to start their business is the common legal needs, like business formation and registration. I said they need assistance with choosing a legal entity type, drafting articles of association, and compliance with reforms. Because maybe they know that there must be statutes, and maybe they've signed some contracts in their life before. But once you have to draft the contract yourself for the first time, it's a different case. Also, the tax compliance, so the VAT registration threshold is 50,000 euros. But how do you know that what kind of turnover you will have if you're just starting your business? You have to know it, kind of anticipate before you even start your business. And also the labor law, like drafting all the contracts and compliance with minimum wage, and you don't know if you can afford the minimum wage before you have started your business. Also the contract enforcement disputes. The court litigation is like 3 to 5 years in civil court, which is about the medium level in European Union. And as a government, we are proud of these results because we are in medium level, but for entrepreneurs, it's still too long to wait 3 or 4 or 5 years. So when opening a family-owned cafe, it should be all about selling good coffee and selling cakes and creating good memories for your customers. But turns out that a big part of your work is navigating these administrative procedures. And once we talk about administrative procedures and administrative burdens and bureaucracy, we must also think a little bit what we understand as bureaucracy. Because some 20 years ago, we would understand bureaucracy as something over-excessive procedures, over-excessive documents, and we knew how to fight it. We just need to cut out those over-excessive documents, and that's how we fight the bureaucracy. But turns out the truth that nowadays in Latvia, and I believe it's also all over the European Union, we have already cut out all the primary over-excessive documents. So all the information that we still need, because government need to look after tax evasion, government need to look after the money laundering, government need to protect the employment, government need to look after some hygiene standards after all. So all those administrative burden, it's not pointless as we used to think about bureaucracy. We just need to eliminate it, and then everybody's happy. So there is some kind of dilemma nowadays that actually those administrative procedures must be performed. But still, today entrepreneurs understand it as administrative burden. And I think that the perception of bureaucracy has changed because people understand as bureaucracy the things that where they don't understand the purpose behind the procedure they must perform, or the process is still time-consuming and they are not. It requires interaction with multiple government online tools to fill in information, and they do not understand why they need to do that. That's what people understand as bureaucracy. But on the government side, we see it as very valuable information that we need for the society. So, how to solve this problem? I'm glad to say that since summer this year, the Latvian Enterprise Register now have this service that we call ultra-fast company registration service. And this is tailor-made for people who want to register their limited liability company. And maybe they do it maybe the first time in their life or maybe the second time, but of course they do not work with those documents on the everyday basis. So what's its ultra-fast registration? What should I do? How do I do it? So imagine I'm the entrepreneur and I want my cafe. So I go to the web page of Enterprise Register and I need to push the button with registration with system-prepared documents. Then I must fill in a company name, company legal address, share capital amount, and founder and board member information. And then I must push the button for the system to prepare the documents, and then system generates the application for the registration, decision of the establishment of the company, articles of association, and shareholder register section. Then I need to sign those documents with my electronic signature. I need to push the button, pay the registration fee, which can be done in seconds via your internet bank, and then I need to push the button, apply for the registration. So people who were looking at the time when we were preparing this procedure says it takes 5 minutes. If you do not have to think about how to name your cafe, it takes like 5 minutes to fill in those actually 4 or 5 fields, and your documents are generated by the system because, you know, most of all, they're very typical. Yeah, very typical. So, what is the conclusion? That small and medium enterprises typically enter the market to earn living and applying their core skills. Whether that's a taxi driver or hairdresser or carpenter or local shopkeeper, for these entrepreneurs, any activity beyond their daily work life seems like an administrative burden. However, requirements related to taxation and labor law and sanitary safety cannot be simply eliminated by government. Governments must ensure compliance with tax obligation and social security and hygiene standards. So, Latvian answer to this seemingly dilemma question is that we think that the only viable solution is the introduction of so-called third-generation digital services. You can call it also the digital disruption, and you can call it people-centered services. These services must go beyond simply online forms. They should actively assist the applicants for drafting documents they never prepared before, for guiding them through the procedures and provide clear explanations for requirements that are not part of their everyday life and everyday business. Moreover, the execution time for such services can no longer be measured in months or weeks or even days. Modern digital solutions must deliver results within hours or ideally within minutes. Ideally, that's just 5 minutes. Well, thank you.
Thank you very much. Big applause. And congratulations also the Japanese experience, but especially also this one for I like very much also the name, no? Ultra fast, no? Procedure. 5 minutes is look like very ultra fast. It will be difficult to make it faster. So congratulations, because I know what that's mean to create a small and medium enterprise. And I mean, what you say is they should focus on the work they do, coffee or whatever, and let's focus on the justice. And so congratulations, I think it's a good example for all of us. Now I will ask to ask Udo Jut-Ilo, Chief Executive Officer of the Hague Institute of Innovation Law, also to talk or to comment about the debate we are having now and the question we made before.
Thank you very much. It's a pleasure to be here, to be on the stage with this fascinating panel. You know, just like the last speaker said, behind every small business, there's a story. And in places like Africa and the Middle East, behind every small business, there's a community. And this community, their sustenance and day-to-day needs are met by this small business. So if you envision a small business in my part of the world, imagine uncles, aunties, brothers and sisters, friends, cousins who have become brothers and sisters. They're all part of that business. And so any day that that business doesn't open for any reason, you are not just dealing with one person who is the business owner. You're dealing with a community. Secondly, in a lot of places, take Tunisia for instance, 90% of small and medium-scale businesses have only one employee, and that's the owner. And so everything starts and ends with this person. If they don't show up for work, you've got a problem. The reality is that when the system actually enables a small business to function, you are feeding a community. But you're not just feeding a community. You're getting higher tax payments by this business. You are getting higher spending power by this long community of people associated with this business. You are empowering people and by extension creating a stable society for yourself. And so it is enlightened self-interest really for governments to invest huge resources in ensuring that small businesses thrive. And the numbers bear it out. In Tunisia, 99% of private businesses are small scale. In a place like Ukraine, it's above 80%. They contribute almost 50% of the GDP. They employ more than 70% of the population. And so you would think this is simple. Come on, just do this and everything is fine. But it's not, for a number of reasons. One is that in most parts of the world, governments do not even understand the need of small businesses. And so in a lot of times when they develop policies or guidance notes or regulations, they are not envisaging a single mother with a baby on her back sitting by the road corner selling corn. They are not envisaging her. They're envisaging a proper business, so-called. And so the regulations do not align with the reality of the bulk of the users of that regulation. Secondly, the system sees these businesses from the eyes of the system, not from the eyes of the small businesses. Again, a misalignment in terms of what is important and what is needed. And when that is not aligned, it becomes hell for those businesses to thrive. And clearly, they've got a problem. In a place like Ukraine, when we polled and interviewed almost 900 small businesses, literally more than half of them have legal problem. If that legal problem by any mistake gets into the court system, it costs them averagely $42,000 to sort it out. In Tunisia, if by chance it gets into the formal justice system, it takes more than 500 days. Now you would think after 500 days they will get all their money back. They would have lost 21% of the value of the money that they were trying to claim from the court. And so it doesn't work. It simply means that when small businesses have legal challenges, they will probably die. Keep in mind, you've got one chap feeding a community, stuck in court for more than 500 days trying to sort out a problem, and for every time he or she is not in the business doesn't work because it's one person. And so the first hurdle is to understand the peculiar nature of these challenges and tailor solutions that meet them at the point of their needs. In Tunisia, we interviewed 2,000 small businesses. 60% of them have had legal challenges in the last 2 years. 80% never resolved that challenge. And of course, I've talked about what happens when it gets into the court. And there are not life-threatening challenges in that sense, but to them it's life-threatening. It's about debt recovery. It's about financing. It's about landlord problem in their places of business. Sometimes it's about harassment of government officials. It's about filing documents that is necessary for their business to thrive. But they may sound simple, but they are not simple for these small businesses because of what has been explained here, what it takes for them to be able to comply with those things. And so in a place like Tunisia, we went into conversation, and that's one thing another point I want to make. If you want to solve the justice problem of small businesses, it's not just the Ministry of Justice, it's a whole society approach, because their situation is implicated in the Ministry of Finance, in planning, in economic development, in land, in agriculture. It's all over the place. So it is not something that the Ministry of Justice can solve. And that point must be made clear. The solutioning is a whole society approach. And in a place like Tunisia, where we developed the employment justice platform that allows labor officials to sit in the comfort of the offices and manage employment disputes and provide solutions. That system is not housed in the Ministry of Justice. It is housed in the Ministry of Social Services, because that's where it's supposed to be. Again, the whole society approach. And that is able to provide about 300 inspectors with the necessary tools that they need to do their work effectively. Similarly, we were able to work with entrepreneurs to design products that allows people to go online and get questions on basic legal challenges that they face, as well as get templates of contracts, but in this case it's not 5 minutes. Get templates of contracts that they need to do their business. I will conclude by saying that understanding the peculiarity of the various businesses, various locations where they are, seeing the justice system from their eyes and designing bespoke solutions that address their problem is difficult. But you can also think of local solutions. In a lot of places in Africa, in marketplaces, there are very strong mediation platforms. But in a lot of places, governments do not interact with that platform. And that is a place you can locate some solutions that are close to the people. You don't need IT, you don't need tech to do this. There are already existing community-led initiatives that small businesses are using to deal with their problem. We need to pay attention to that and invest in them. I will close by saying that small businesses are not just tools for economic empowerment. They are also tools for transformational technological development. The Apples of this world, the Googles of this world, we are once small businesses, but they were able to thrive in an environment that provided enabling legal framework, easy access to credit, and simplified processes for small businesses to grow. And they've become what they are today. And so, the message is simple. If the justice system works for small businesses will work for the economy. And if the economy works, you live in stable societies. Thank you.
Thank you very much. Thank you very much, Udo. You are absolutely right. I mean, and also in Spain, we have 99% of the companies are small and medium enterprise that represent 2/3 of the employment and also 2/3 of the GDP. So it's very important. And as you're right, also small companies sometimes they face solve big problems with different things that they have a good idea, they have good product. Go on because of this situation. So digitalization, we can see also, we have seen another example, the third example today, that how digitalization and working on justice can increase the competitiveness and they survive, to get that more small and medium enterprises can survive and do their job they do, and also, of course, is essential for the economy of the country and for the good of the society. And now, the English would say last but not least, we have Ana Gallego Torres. She is the Director General for Justice and Consumers in the European Commission. So what is the vision from the European Commission about this very important issue?
Good afternoon, and thank you very much for having me. It's really an honor to represent the European Commission in this forum and the Roundtable on Equal Access to Justice. I want to highlight here the pioneering work that the OECD has done in this area, and which is being recognized at EU level by accessing and recognizing and adhering to the OECD's recommendation on access to justice and people-centered justice systems. It's difficult to speak after these three panelists that have really presented a very varied reality in terms of what happens in the member states, in countries, and in the reality on the ground when small and medium enterprises want to invest, want to act for the economy, and they face regulatory problems, and they face particularly SMEs, important hurdles to invest and to grow. And this is something that we in the European Union are very concerned about the growth and the competitiveness, and how the law can help enterprises, startups, scale-ups to grow and to make the system work for them and not against them. In this session, we are invited to reflect on how the justice system can be a catalyst for that, for growth and competitiveness. And I would say that what has been an essential consideration for the European Commission is that developing a rule of law and justice policy is one of the elements, one of the catalysts for working for the business sector. The rule of law plays an important role, of course, in functioning of the EU economy and ensuring that the rights of businesses as well are defended, that corruption is punished. We haven't spoken enough about how corruption is one of the killers of competitiveness and growth, because it distorts and disrupts the market and offers an uneven playing field for companies. An effective framework to combat corruption is also very important for the economy. And also the justice system is the one responsible to ensure that contracts can be upheld and are enforced. The justice system ensures also that the business environment in which laws apply effectively and uniformly, where businesses can work in another country on an equal footing with local companies and ensure cross-border investment, and budgets are spent on a transparent and objective basis. This is also one important element to fight corruption. So a well-functioning and fully independent justice system is key for investment protection and are associated with greater productivity and competitiveness. Where justice systems can guarantee the enforcement of rights, creditors are more likely to lend and invest. Transaction costs are reduced, and businesses are more likely to invest as well, have higher confidence, and are dissuaded from opportunistic behavior and again from corrupt practices. Moreover, efficient dispute resolution is providing businesses and SMEs the means to address contractual conflicts quickly and to save money for doing business, which is what they have to do. So this is why the Commission, the European Commission, has developed a robust rule of law toolbox, because we think it's an enabler of growth and competitiveness. And the rule of law toolbox is aimed at preventing problems for emerging or deepening and to responding decisively to the challenges. And among these, we have an annual EU Justice Scoreboard, which is a comparative information tool that provides information to the EU, to the member states, but also to investors and companies, providing information about the effectiveness of the justice system. And we believe that this is an enabler of investment. We provide data on the efficiency of the justice system, on the quality of it, and the independence of courts, which is a guarantee for a fair and an effective dispute resolution. And it fosters data-driven reforms to improve the situation. Also, we have an annual rule of law report where we monitor developments in all member states and 4 of the enlargement countries. And since 2020, where the first rule of law report was adopted, the report has served to bolster mutual trust and inform best practices. This is a very valuable information tool, not only for public authorities or for civil society organizations, but also for businesses. And because stability and reliability in markets are essential for providing a business-friendly environment, in 2025, we added to this rule of law report a single market dimension. By this single market dimension, we acknowledge the fact that the justice system is an enabler of economic activity and provides the conditions for companies to thrive and to solve their disputes in a fair and effective way. Commissioner McGrath, who's the commissioner in the European Commission responsible for rule of law and justice systems and consumer protection, has launched a dialogue with the main justice stakeholders to discuss on how justice-related policies can support competitiveness and ensure prosperity for European businesses through growth. Modernized EU civil and company law rules, as well as further digitalization of justice, are key importance to strengthen the EU economy. We have spoken here extensively about the digitalization of justice and the possibilities that are opened through AI. This can also work in favor of more effective and more quality justice systems. Because a set of predictable and appropriate rules can help plan and compete effectively in multiple jurisdictions. If you consider the European single market, we are concerned that companies, even if they can, in theory, operate cross-border, but they are deterred from doing so because of the regulatory differences and because of the fragmentation of the single market. So a predictable and appropriate set of rules is also an enabler for operating cross-border. And of course, here I want to mention as well the judicial cooperation, because when acting cross-border, companies also need strong, predictable, and fast and reliable judicial cooperation systems, whereby cross-border litigation can work without excessive delays and with predictable outcomes. Company law and corporate governance are also key levers for providing companies with a competitive and business-likely friendly legal environment. And here I do want to mention one project that is in the pipeline and that is raising lots of expectations for particularly small businesses, startups and scale-ups businesses, which is the 28 regime. 28 regime makes reference to an additional regime on top of the 27 member states of the European Union, and is one of the key initiatives to enhance European Union's competitiveness and help companies overcome barriers when setting up and operating in the single market. And one central element of this 28 regime will be an ambitious EU corporate legal framework. Also, digital solutions will be key to develop existing tools and facilitate investment and attract investments throughout the EU. Finally, we are aware that the EU's competitiveness will increasingly depend on the digitalization of all sectors, and it will drive investment. Therefore, the Commission is proposing also to increase funding, including for the digitalization of justice, to make it more effective, more agile and more predictable through the future financial framework. We hope that Member States will also follow suit when designing their policies. Thank you very much.
Thank you very much. No, in fact, thank you very much, Anna. It's very important because European Union, at the end, is almost 500 people and a lot of many small and medium enterprises also, and it's very important for the economy and for the sustainability of the region. Now we have 5 minutes, and as we said, if you have now questions to make to our great participants in this roundtable, so you are more than welcome. So I suppose there are many questions. And if not, you can do it later to them directly, but some questions, and then, okay, I will then this few minutes, no questions, then then I will use this 4 minutes, not too much time. First of all, to thank you very much for sharing your experience, your knowledge, and your talent. It has been a great and inspirational words. But I would like you to say some final words or recommendation or something you could recommend to your colleagues in other regions or in other countries, how to approach this digitalization of the justice for a small and medium enterprise. We have seen that, of course, this means speed is important, low cost, and also what we said also before, no? The small and medium enterprise can focus on their business and then cannot get awake during the night because of justice issues, because that can be solved easily thanks to also the support of digitalization and the effort from the countries and from the ministries of justice in the different regions. So you have one opportunity to say whatever you want for the public. We'll start with you, Anna. Okay. We can do it the other way around. We do it this way.
Okay. Let me, because we have extensively spoken about digitalization of justice systems and how it can bolster competitiveness. But I would like to focus and maybe say a few words on the process and the methodology to come up with innovative policies as well. And here I would like to build on what Udo was referring to, which is the reality on the ground for companies and investors. And here I think the methodology and the process to come up with innovative policies has to be participatory. We need to listen to companies, and we need to foster participatory dialogues, to listen really to what the practitioners have to say, and by listening to the companies and to investors and to small and medium enterprises, identify the obstacles, the hurdles, the difficulties they face in their daily lives in the economy. We need to shape policies that respond to those needs. And this seems quite obvious and perhaps too straightforward but actually it is not it's not so obvious. Yeah. Because sometimes we define policies that look very well on paper, that make a lot of sense from a legal point of view and let's say meet the needs of public authorities, but they are not necessarily meeting the needs of enterprises. So I think there we have a responsibility to listen more to companies.
Okay, thank you very much, Anna. Midori? Some small final words?
No, thank you.
Okay.
Okay.
Then Anda?
Yes. I would like to say about digitalization that, you know, in the first and second generation of digitalization, we just took our paper procedures and made it digital. But in those digital procedures, all the faults and all the disadvantages of paper procedures still remain. So in order to serve our customers, our public, we need to forget, as a government, our existing digital infrastructure. We need to forget the services which are convenient to the state agencies and not for customers. And we must ask for our customers, how do they imagine their services? What is convenient for them? And only then we can come to this third generation of digitalization or digital disruption. Well, it is easy to say, it's not always easy to do it. Yeah. But at least if we understand what we must do, there is a hope that we will do it one day.
Excellent. Congratulations. Udo?
Yeah, thank you. The conversation here is justice for growth and competitiveness. But it's not settled. A lot of countries, a lot of governments do not understand the role of justice in driving development. And you can see that in their reluctance to invest in some of these issues that opens up the justice space for businesses. And so I think part of what I think OECD, the EU, and other countries here need to do is to push that message across. We're talking about the global gateway of the EU, and the justice component of that initiative is not very robust. And so that is where we need to start from, to showcase that linkage and perhaps use that to unlock more resources in providing justice services, because funding for justice doesn't even exist anymore, the way we used to know it. And it's a struggle. Few countries are the ones still invested in that area. And when you have that kind of situation, and you're saying it is the bedrock of economic development, then that becomes a bit of an irony. If it is the bedrock, the resources should be available for it, not just for military expansion. So my message is that we push that call out there so that governments can begin to prioritize a little bit carefully, because it is in their best self-interest.
Thank you very much, Udo. Thank you very much, all of you. Have been great sharing this roundtable with you, and I think has been very inspirational for all of us. Thank you very much. Thank you.
Thank you very much. I think it is now time for a brief break. I'm just looking at the bosses of my bosses. Yes, I am right. So we will reconvene here in about half an hour. Or in exactly half an hour. Let me be strict. Pas de questions.
Ladies and gentlemen, we kindly ask you to please take your seats as we prepare to commence.
Por favor, solicitamos a todos los asistentes que vayan tomando sus asientos.
Ladies and gentlemen, we kindly ask you to please take your seats as we prepare to commence.
Por favor, solicitamos a todos los asistentes que vayan tomando sus asientos.
Ladies and gentlemen, we kindly ask you to please take your seats as we prepare to commence.
Por favor, solicitamos a todos los asistentes que vayan tomando sus asientos.
Ladies and gentlemen, we kindly ask you to please take your seats as we prepare to commence.
Por favor, solicitamos a todos los asistentes que vayan tomando sus asientos.
Come and bring somebody close.
Yeah. Okay, while we are waiting, can I say something and then also ask you something? So I'll start by asking you something, and that is, would you mind coming a little more to the front so that it's cozy, we're close to the speaker, we can have some real engagement with the panel. So everybody at the back, we welcome you here. So that we're closer together as we talk about leadership, one of the most important topics of the day. So once again, please feel free to move a little closer. We don't bite. We're fairly friendly. And we won't unexpectedly give you the floor. So it's completely safe to sit up front. The second thing I'd like to say on behalf of the organizers is that there is, as you may know from the program, a dinner that starts at 8 p.m. in the Palacio Parcent. The Palacio Parcent, 8 p.m., to which you are all invited. We hope very much that you will come. It will present another opportunity to forge networks and to get to know each other better. 8 p.m., Palacio Parcent. And I think I see Justice Montalban Huertas coming. Welcome. Okay, I will briefly introduce the panel. Why don't you sit here? Yes. Very pleased to meet you. Sam. So this is the final panel. The final panel on the topic of leadership. And I was given a deceptively simple definition of leadership by somebody a while ago, which has always served me well. And that was asking three questions. Is there a plan? The second question, is there a team? And the third question, is the team working on the plan? That's what leadership is about. And this has extra complications in the justice system. A friend of mine who was a Minister of Justice for a while, he once said to me, I was the captain of a large ship, but I did not have control over the rudder and over the engine. I could be fired for a lot, but had control over a lot less. So as Minister of Justice, he could be blamed for everything and lots of stuff, but he had very limited control over things that were happening. A very different perspective from being the CEO of a company, Or a Chief Justice who said to me not long ago, we know exactly what to do, but we can't get the budget allocations from the executive and from Parliament. In fact, they're cutting us because they don't like us. So it's complex. But leadership is absolutely key if we want to make justice the cornerstone of resilient societies and thriving economies. So that's what this final panel is about. And we have Judge Immaculada Montalbán Huertas, the Vice President of the Constitutional Court of Spain, who will moderate the panel. We have Justice Karakternatis of the Supreme Court of Canada. We have His Excellency Alpha Sesay, the Attorney General of Sierra Leone, Judge Samuel Arias Orenzo of the Supreme Court of Justice of the Dominican Republic, and Kirta Heine, Senior Ministerial Advisor of the Ministry of Justice of Finland. May I ask you to take the floor? Where are you? And Teresa van der Lubbe. This is what Dutch people always do. Dutch people forget Dutch people. Oh my God, this is really awful. So blame me. Teresa, I am deeply sorry. I will get on my knees to apologize. You're on another page. That's what happened. Thank you for reminding me. She is Policy Coordinator on Access to Justice at the Ministry of Justice of the Netherlands. Over to you, Judge Montalbán Huertas.
Buenas tardes y bueno.
Good afternoon, one and all. It is an honor for me to share this afternoon pondering on justice systems and the importance of a cooperation between the executive and the judiciary power to strengthen the rule of law. The present panel, entitled Leadership in Safeguarding the Rule of Law, instantly evokes the idea of the rule of law as a foundation for democracies and as a compendium of principles accepted commonly by our countries. The principle that no one is above the law, and that includes the public powers, the executive, the judiciary, and the legislative power. They are all subject to the legislation. And second, it also evokes the principle of the fundamental rights of individuals, which are a right in court, not just a mere declaration or written statement. The basic human rights are to be guaranteed by our courts of law. A third pillar of the rule of law is the independence of the magistrates that must remain impartial in conflict resolution. And one fourth pillar, those court decisions, whether we like them or not, are final and meant to be respected and abided for the good functioning of institutions and the rule of law. This afternoon, we're gathered here to contribute ideas on these two concepts: judiciary independence and mutual respect and cooperation among state powers, particularly executive and legislative, because The two ideas of cooperation and judiciary independence are the key for the good performance of the rule of law. I must say that this matter bears such importance that only 2 weeks ago we held the 6th World Conference on Constitutional Justice in this very city of Madrid, with more than 80 constitutional courts from across the world in attendance. One of the priority topics was the need to defend the independence of the judiciary power at this moment in time and in history where we face problems left, right, and center coming from climate change and the eruption of new technologies, social media, issues stemming from the lack of citizens' trust towards their institutions, and problems arising from disconsiderate criticism to institutions that ultimately undermine that the very mission of those institutions. The president of the Constitutional Court of Spain, President Candido Conde Pompido, did point out that some of the problems that directly affect the independence of magistrates come mostly from ill-willed attempts to elude court decisions, despite the fact that these are final rulings that are to be implemented according to the legislation and the Constitution. Beyond these attempts to elude the justice, we also detect political campaigns and media campaigns that aim to discredit and undermine our courts of law. I must say this is a concern shared by many other courts of law when we met only a few days ago in Madrid. We are utterly concerned about this context where more and more new formulae are required to strengthen our institutions. Apparently, the instruments we have availed ourselves of until now are at present obsolete, insufficient. We need to adopt a proactive stance in this new concept of new technologies and social media. Having said this, strengthening our institutions and adopting active leadership policies to lead those in decision-making positions in their institutions is now more than ever a must. We must remain aware that we need to adopt, as I said, a new stance and a new active attitude to boldly defend judiciary independence. No judge can or should feel any kind of pressure when it comes to make a ruling. Judges must only be subject to the legislation, the international standards, and the Constitution. No further limits beyond that. Second, we need to adopt an active position to promote the integrity and accountability in our system. Corruption will not be tolerated. In our environment, we need to proclaim zero tolerance to corruption, and we must be impeccable in our professional behavior and personal ethics. Third, we also need to play an active role in promoting transparency, accountability in our activities, and accountability of our performance. Being accountable for our work and our performance is not incompatible with independence and autonomy. Quite the contrary, it generates a further trust from citizens. At the same time, we need to adopt a clear attitude in favor of learning and institutional culture among our components, because only thus can we face this new context we are immersed in, where there are clearly serious attacks to the judiciary independence in democratic countries. So 3 final concepts that I believe should guide the analysis of this complex situation. First of all, assuming that judiciary control of power is tantamount to the ordinary performance of the system. When constitutional justice controls the executive power, or the legislative power for that matter. Just as an example, in Spain, we decide whether the legislation is constitutional or not. We have the prerogative to pronounce legislation that does not adjust to the Constitution as null and unconstitutional. And this should not be seen as a crisis. This is the way a democracy works, as established by, in this case, our Constitution. And we need to interiorize that. It is our duty to motivate, to reason, to explain the rationale of our decisions, or behind our decisions. Beyond understanding that the judiciary power prevails on the other two, the kind of leadership we need to adopt must include defending the independence of justice under clear, practical rules. Our courts of law need to remain transparent when it comes to picking the staff that will join our courts of law. It is our duty to set up schemes and procedures that will give citizens access to the activities and internal performance of their legal system. Because in sum, leadership is all about keeping the trust of our citizens. Because justice is not only meant to be independent, because it is printed in our Constitution, it is also meant to be independent and at the same time be perceived by the public, by our citizens, as independent. And this, of course, calls for a closer contact with our citizens via innovative formulae or recipes, using or making proper use of new technology, and opening ourselves to society to help them know us better and therefore trust us. I will wrap up, well, first of all, by thanking the OECD for the invitation to participate, and also Mr. Manuel Olmedo, Secretary of State, for his kindness in letting me spend this time with you. Finally, the rule of law is strengthened by the daily exercise of our responsibility. We must or lead by example. We must play by the rules, and we must remain ethically, politically, and legally in charge. Each and every one of us gathered here today, and everyone in our teams, and all those who have the privilege to serve in our institutions. In this session, we will be discussing these concepts with the distinguished experts, top-level experts, which I greet from this podium, and which I am about to introduce as they deserve, because it is truly an honor to be in such outstanding company coming from different countries. Before I do so, however, I believe we have a message from Andromache Caractasanes from the Canada Supreme Court. So let's hear her message, and after that I will introduce the magnificent speakers we have for this session. Bonjour, hello.
It's about rules. It is not just about law. It is about a just rule of law, a promise of justice, a promise that no one is above the law and no one is beneath its protection. This promise is essential to modern liberal democracies, and as this panel will discuss, must be safeguarded for all. Au cœur de la primauté du droit se trouve un processus de collaboration respectueux entre
We need respect among the different brands of the government, civil society organizations, and citizens themselves.
Leadership in strengthening a just rule of law, in maintaining legitimacy and public trust. Judges are not just impartial arbiters of particular disputes. We are stewards of the legal system. The judiciary plays a central role in nurturing the rule of law in every healthy democracy, including maintaining access to justice for all. And not only in our courtrooms, we are often collaborating with other justice professionals, the government, and with communities to ensure a people-centered justice system. Indeed, all law is ultimately about people and for people. I would highlight two examples of judicial leadership in the Canadian context. In 2014 case, Reiniak versus Malden, the Supreme Court recognized the access to justice crisis and called for a culture change for timely, affordable access to justice. We gave judges the flexibility to tailor the process proportionate to the needs of the particular case. We explained, without an effective and accessible means of enforcing rights, the rule of law is threatened. Judges also provide extrajudicial leadership. For example, I serve as chair of the National Action Committee on Access to Justice in Civil Family Matters, bringing together a broad group of justice participants, acting as a champion for people-centered justice. Pour moi, une vision de la justice centrée sur...
For me, individual-centered policies must include overcoming our perspective and institutional prejudice and truly placing people at the core of our work with the purpose of creating a justice system that is inclusive and accessible for all.
Leadership and commitment. The rule of law does not sustain itself. It requires vigilance and leadership and access to justice for all. Lawmakers, governments, citizens, lawyers, and judges alike. We must cherish the rule of law as a living commitment to the future. Because access to justice is about the kind of society we want to live in. It is about the just rule of law essential to democracy and to peace. Justice is a basic human need, a common good. It is fundamental to the pursuit of a good life.
Muchas gracias.
Thank you. Thank you for this clear presentation. I should say, as the chairperson of this panel, it's an honor to have those prestigious panelists as the ones that are with us today. Alpha Sesay, General Attorney and Minister of Justice in Sierra Leone, Dominican Republic. I will ask you to say your name. I don't have it. Samuel Arias Aretno. Welcome. He's from the Supreme Court of the Dominican Republic. Welcome to Madrid. We also have with us Kirta Heine. She's coordinator of the relations with the Ministry of Justice. Is that correct? Welcome. And the next speaker, could you please say your name? Teresa. And her work is at the Ministry of Justice, is that correct? Sí. Welcome. We're going to start with our first panelist, Alpha Sesay. You have the floor. Thank you.
Thank you, George, for that introduction, and thanks to OECD for the opportunity to be in company of other experts, amazing panelists, and of course, with you all who are experts really in what we're discussing here. But I mean, it's good that we are all able to share different perspectives. I think first is to really agree with all of what the judge said about judicial independence, and of course also about what we heard on video from Canada about the importance of the rule of law. It is something that is really deeply rooted in our justice system in Sierra Leone. It is really fundamental. We in Sierra Leone practice a system of separation of powers. Right, we have the three arms of government: the executive, the legislature, and then the judiciary, which is headed by the Chief Justice. But then we underscore the need to work together, to collaborate, of course, whilst respecting the independence of the judiciary. We also underscore the need to work together. This is actually situated in our country's medium-term national development plan, under Enabler 2, which has to do with inclusive and accountable institutions. So medium-term national development plan really runs from 2024 to 2030. And in this we have said that we'll seek to ensure that all citizens benefit from a fair, impartial, and effective justice sector through enabling increased access to justice, expedition of justice, protection of human rights, equal opportunities for economic development. So with this, of course, we make emphasis on strengthening access to justice, which is something that we do through the judiciary, right? And then, of course, with various other actors. But we also realize that this is something that has to be done in collaboration with each other. So what we have in Sierra Leone, for example, in my position as Attorney General, I also serve as Minister of Justice. So yes, I am not on the judiciary, but then I sit in cabinet. And so concerns that are of importance to the judiciary, I communicate these in cabinet. Issues of concern to the executive, I communicate as well to the judiciary. And we do this in a respectful way, wherein we are respecting the independence of the institution. In our constitution, there's something called, there's a body called the Judicial and Legal Service Commission. That commission is actually responsible for appointment, promotion, and discipline for judicial officers. The Chief Justice chairs the Judicial and Legal Service Commission, but then the executive is represented through the Public Service Commission and through my office. Well, that commission makes recommendations to the president for appointment of judges, and of course the judges have to go to Parliament for approval. And of course also that commission makes recommendations for promotion and then addresses issues of discipline. So in that space, yes, the executive and the judiciary work together really closely. But then, there are certain practical things. The public does not see the Judicial and Legal Service Commission, right? So the public really sees how the justice system works. If cases are stuck in court, that is what the public pays attention to, right? The previous panel spoke about the justice system working for SMEs, right? So yes, when SMEs have legal issues that are stuck in court, yes, it's the judiciary. But then the economic implications are of concern to the government. And really, I realized that since I moved into this position 1 year ago, I've had a lot of people come into my office expressing concerns about what is happening to cases in the judiciary. So sometimes I have to explain my role to them. But then, I also use that opportunity to engage the Chief Justice, to engage judges and say, these are concerns that we get from members of the public. Because that is how the public sees it. As the President likes to say, when the judiciary doesn't function very well, sometimes members of the public don't pay attention to say, it's, an independent branch of government. They just say the government, should take responsibility for the functioning or lack of functioning of the judiciary. How have we really worked in practical terms? When we set ourselves to develop the justice sector reform strategy, we ensured that we brought together all actors that are implicated in the justice sector. That includes my office, the Office of Attorney General, Minister of Justice, the Justice Sector Coordination Office, the coordinator is right here. The judiciary, the Chief Justice has a representative on that body. Then other government ministries like Ministry of Internal Affairs, Gender, and then you have Sierra Leone Police, Correctional Service, etc., etc. So in that space, we have used the enabler in our justice sector reform strategy to develop a countrywide justice sector reform strategy, which we own together. So in implementation of this strategy, we have to work together. If we are talking about deploying a range of justice services across the country, the Chief Justice has to be on board in providing that leadership. I have to be there to provide that leadership, so that way we're working together. When we talk about really providing access to justice, especially for marginalized communities, we do so mostly through our country's legal aid board. The way we've structured our legal aid board, the chairperson of the legal aid board is a judge, right, nominated by the Chief Justice, but then the executive director of the legal aid board is appointed by the president based on advice from the Attorney General. So you see that in that space, managing the work of paralegals, providing legal representation to indigent citizens, those are all things that we do together. Same with the prison courts, right? We run prison courts across the country. We review cases. We actually get the courts to operate within the correctional service facilities. This we do together. Same with the way we manage customary law, because our legal system actually, yes, we have the general law which we practice, which happens in court. But then, as we all know, a lot of other legal issues get resolved through informal and customary systems. The Chief Justice appoints the chairperson of the local courts, but then the Attorney General has a state counsel who is a customary law officer, there to provide guidance to that chair of the local court. So these are examples of how we are really working together. But we also understand that sometimes, yes, we make progress and then we have to step backwards, right? Because sometimes, yes, we have all of these good systems in place, but then they actually happen when you have people with credibility, people of integrity, people who really care about justice services for the people. So yes, as you will have in other countries, sometimes when you have people in these positions, if it's a Chief Justice or Attorney General, if these things are not like super important, yes, things are slow. We acknowledge that. And so that is why in our reform strategy this time around, we are, yes, focusing on individuals, but really putting greater attention to building systems in place so that even when individuals move, these systems are in place to work for the people. If we want to digitize the justice delivery process, instead of training a judge or a magistrate, yes, we build a system so that way it really works for the people. Yes, we're working together to ensure that there are code of conduct that will guide how judicial officers function, whether it's a judge, a magistrate, or a state council working in government. So really, in Sierra Leone, whilst we really respect judicial independence, we also really acknowledge that for these processes to work for our people, we have to work together. Without that, we're not going to get the results that we really need. Thank you.
Muchas gracias, señor fiscal general.
Thank you, General Attorney. I think we need to highlight the importance of your experience in legal aid. This brings to mind one of the key messages of the next OECD report, making justice system more effective and people-centered, related to the importance of coordination and collaboration to guarantee that the judiciary works for a rule of law centered on the people. Congratulations for your experience and thanks. Now we are going to give the floor to the representative of the Dominican Republic of the Supreme Court. Samuel, you have the floor. Good afternoon. Judge Montalban, I'd like to thank the OECD and the Spanish government for their invitation to participate in this panel. In a global context of democratic drawbacks, it is highlighted that 2025 is the fifth consecutive year of impairment of the rule of law, with 68% of countries with an important erosion of judicial independence and the limits of power. In the Dominican Republic, this is the country with the more global progress in the index of the rule of law in 2025, with an improvement of 2.1% in the general index, leading Latin America. In this scenario, our commitment is clear: to lead from the independence, but with openness, responsibility, and transparency. In our country, we have built an institutional relation with the executive power based on balance, constitutional respect, and collaboration limited to the legitimate aims of public policies without affecting the functional autonomy of judges. This collaboration is based on clear frameworks, but coordinated participation in interinstitutional dialogue, joint work about innovation and transparency, and our integration in a national action plan for an open government. This participation states that cooperation among the powers does not mean any subordination, but a mutual recognition of responsibilities to guarantee different rights. Therefore, open justice is now a foundation, and not as a slogan, but as a management model. The Observatory of the Judiciary is not only responsible for publishing data, but it generates dialogue, social participation, and an ongoing monitoring of the judiciary performance. Our social participation policy has allowed the co-creation of regulations together with the public, the academia, and legal professionals. This consolidates and provides legitimacy, trust, and democratic co-responsibility. We have paid special attention in judicial teaching and learning to get close to the communities, to explain our function and promote civil culture. Through the program Justice and Society, judges participate at public spaces education centers and community organizations, reinforcing the idea that justice is not a distant power, but an essential public service that is in the hands of the citizens. We also acknowledge that there are still structural challenges due to the fact that we live huge backlogs that require innovative solutions. We have responded with a strategy to alleviate our backlog with modernizing our proceedings and public management measures. The key is to reform while keeping accountable, working with transparency and including the citizens. In summary, our experience shows that a strong judiciary is not the one that is only independent, but a power that is independent and transparent, autonomous and collaborative, impartial and close to the public. Thank you.
Muchas gracias a la...
Thank you to the Dominican Republic for their illustrations and their experience on transparency, this concept that we can find in the key messages in the report that will be published by the OECD, the importance of transparency and accountability to the public. Thank you for your very interesting presentation. Now we're going to give the floor to Kirta Eine to present the experience in her field.
Thank you. Honorable Chair, dear colleagues, it's really an honor to be here in Madrid and to have part in this panel, so thank you. I was asked to present you an ongoing cross-sector initiative in my home country, Finland, an initiative that would bring together a wide range of actors to reinforce the rule of law and promote coordinated, people-centered approaches across institutions. In Finland, we believe that trust is built through openness, respect and inclusive dialogue at all levels of society. It is fostered by ensuring that everyone can access public services, that corruption and abuse of power are effectively prevented, and that people feel heard and protected by the system. Trust is also reinforced by a culture of collaboration between authorities, civil societies, and citizens. So our justice system is committed to a people-centered approach. We see justice as a public service, and we strive to make it accessible, responsive, and understandable for all, including the most vulnerable. A concrete example of this commitment is the work of the Working Group on Guarantees of Rule of Law and Development of Judiciary System, established by the Ministry of Justice in 2023. The Working Group's term of office will last until the end of 2027. This broad-based group brings together experts and stakeholders from across the justice sector to strengthen the rule of law, enhance the independence of the judiciary, and improve the quality and user centricity of justice services. So in short, the aim of the group's work is to promote the independence of the administration of justice and the quality of legal protection, as well as the user orientation of judicial services. This working group literally brings together a wide range of actors. The working group consists of 50 members, including chairs, deputies, permanent experts, and secretariats. In addition to representatives of the various departments of the Ministry of Justice, the group includes lawyers, prosecutors, enforcement officers, legal aid attorneys, judges, of course, and so on and so on. The task of the working group is to monitor and assess the development and productivity of the judiciary and to make proposals to promote them. The working group must also assess the cooperation between the different actors in the criminal procedure chain and make proposals for developing the cooperation. In addition, the working group may make proposals to improve the service capacity of the judiciary, streamline operations and promote access to justice. At the beginning of its work, the working group approved a work plan, according to which the work of the working group is divided into 4 phases: identifying the task packages, selecting the measures, the actual work period, and reporting and monitoring the end results. In the first phase, the working group organized several stakeholder and expert hearing events to identify which are the areas where the work of this working group should concentrate at. In the second phase, the working group appointed 6 sub-working groups. 1, crime and the processing of criminal cases. 2, processing of civil cases, mediation and alternative dispute resolution methods. 3, administrative law cases and special court cases. 4, legal advice and assistance. 5, enforcement and the activities of the enforcement authority. And 6, administrative, personnel and training matters. These 6 sub-working groups were instructed to take an innovative and reform-minded approach to development of the judiciary. It was permissible and even desirable to present development directions that seem impossible at this moment. These subgroups completed their proposals autumn 2024. The subgroups compiled their proposals in such a way that they describe the future operating model, which presents the target state of each subject area, as well as preliminary alternative proposals for measures that can be implemented to achieve the target state. The proposed measures aim to highlight the key challenges of the current situation and the goals for 2040s and the range of means to achieve them. A total of almost 170 preliminary alternative proposals for measures were listed. Common themes highlighted in all subgroups include innovations and development proposals related to the use of digitalization and technology, as well as process development and streamlining, some of which also require the development of digitalization in order to be realized. In addition, aspects related to the availability and permanence of personnel and the development of the employer image emerged as common themes. The themes of ensuring and strengthening independence also came up repeatedly. A stakeholder hearing was held on the proposals, in addition to which the proposals of the subgroups were published in the statement.fi service. In this service, all organizations and citizens can make statements electronically. More than 130 statements were received, and all of these statements were taken into account. Based on the proposals of the sub-working groups and the feedback received, the working group listed the preliminary action proposals in different categories. And after this, a total of 27 project groups were established to continue the preparation of proposals that require legislative and/or development measures. The whole administrative branch takes part in this work. Altogether, these project groups have around 250 members. So the work of these project groups is ongoing at the moment. We look forward to seeing what kind of measures the project groups will present to the working group. Thank you.
Muchas gracias por la experiencia.
Thank you for the experience. I want to highlight 2 ideas presented by Kirta Heine. The idea of justice as a public service. This is very important for the evolution of democracies. The judiciary is independent, but it's also a public service, and it has to be committed to the citizens. And secondly, her experience, the experience of her country, shows how it is very important to keep and maintain an institutional commitment towards the rule of law, focus or center in the people, as is been shown in the different working groups with the aim of improving justice service provision. We really congratulate you for your experience. Now we're going to give the floor to Teresa, so she will present her experiences.
Thank you very much, Honourable Chair, Excellencies, ladies and gentlemen. We've already heard some very interesting experiences and examples today. I feel very inspired and challenged, and I hope to inspire you as well by sharing the Dutch experiences to strengthening access to justice, and I'm hoping to consolidate them into general principles that will be of use to you as well. The Dutch government is strongly committed to safeguard and enhance access to justice together, placing the citizen firmly at the center. This is our simple but powerful mission at the core of our national strategy. Every person should be able to find an appropriate and sustainable solution to their legal problem. Our strategy for strengthening access to justice is built on collaboration between the many actors that make up our legal system. This is the cornerstone to success that I want to elaborate to you on. As Ministry of Justice, we fulfill our overall responsibility for maintaining a sound, accessible and future-proof legal system, mainly by facilitating and connecting. The team that was mentioned in the introduction. We have established a collaborative framework that brings together all key institutions, both on a strategic and on an expert level. Judiciary, the legal board, the legal services counter, social lawyers and civil society organizations all play their own vital and indispensable role in this. This structure enables us to collaborate based on shared and individual responsibilities and continuous learning, and it helps us in identifying barriers, develop joint solutions and build a justice system that is resilient, inclusive and responsive to people's needs. Let me share a few best practices. Firstly, the Rechtwijzer initiative, or Signpost to Justice. This is an online tool that offers citizens digital tools to identify and address legal problems themselves with information and referral to appropriate authorities where necessary. This initiative is founded on collaboration between public and private services. It is developed by the Legal Aid Board, together with private partners such as Justice 42 and HIL in the room here today, with support from our ministry. And still, cooperation is sought to enhance the coordination between organizations and to provide a varied, appropriate and affordable range of legal assistance. Rechtwijzer, for example, gives information on divorce and all aspects you have to deal with during your divorce, on renting or on consumer disputes. The website gives useful information, directs to other organizations like the Legal Services Counter, and always refers to legal professionals when this is recommended. Another example is the Community Courts initiatives, which stems from the program Socially Effective Justice of the Judiciary. It is inspired by the community courts in New York. The aim of community courts is to contribute effectively to solving the diverse and multitude of problems that people face in certain neighborhoods. To this end, the judiciary works closely with other professional bodies, such as the Public Prosecution Service, municipalities, probation service, the legal profession, housing associations, and social services. With this collaborative action, they hope to improve the safety, the quality of life and social well-being in those neighborhoods. And let me highlight the Court Debt Officer initiative in Dutch courts, which was awarded the 2025 Crystal Scale of Justice Prize last month. We are very proud, so we mention it every time that we intervene these days. In many cases, judges encounter people struggling with debt. When that occurs, the judge can refer them directly to the court debt officer, a court-based liaison, who ensures that these individuals quickly and effectively receive the right help from their local municipality. And finally, the project called Kopregio, or Leading Region, an initiative coordinated by the Legal Services Counter, together with various local and regional welfare organizations and 7 municipalities of the province of Limburg. Its aim is creating a no wrong door principle, when people seeking legal assistance can quickly find the appropriate help without complicated referrals. Last March, they signed a pact starting with their ambition, and now it's up to them to translate these ambitions into concrete actions within the region. These examples show how innovation and collaboration can and should go hand in hand, preserving judicial independence and integrity while making justice more people-centered and solutions more sustainable. And our efforts do not stop at the national border. We are also actively engaged in international cooperation to enhance access to justice. Together with Malta, Ireland and Italy, we participate in a multi-country project led by the OECD and funded by the European Commission's Technical Support Instrument. It focuses on developing and improving people-centered legal systems. And the success of this project depends on active involvement and collaboration with all partners within our legal system. To this end, we have established a national advisory group closely aligned with our existing coordination structures. And its members are not only informed, but truly engaged, contributing their experience, their expertise, sharing responsibilities, and learning together whenever needed. Be it an extensive OECD questionnaire, famous by you all, or at our cross-sector workshops. These Dutch experiences can offer valuable lessons for other countries. At the same time, we know that success depends on local, legal, institutional and cultural contexts. You will probably not hear anything new when I offer my key principles, but allow me to be some sort of validation for what we've heard today. Firstly, structured support. Provide clear step-by-step assistance to people navigating legal problems at their pace and close at hand. And to echo Margaret, work on the workflows. Second, preserving independence. Ensure that decisions with legal consequences always remain in the hands of qualified legal professionals. And finally, my main message, collaboration is the cornerstone. Truly incorporate collaboration between the many actors of your legal system into the structure of your efforts. This fosters accountability and continuous improvement, embedding shared progress into everyday practice. And don't forget to consider calling on private organizations such as HIL, as their expertise can be of real added value in your efforts. Keywords of today, co-design and whole-of-society approach. Let me end by reiterating that it is possible to combine innovation and collaboration with judicial independence and institutional safeguards. It is, in fact, the best way to build a people-centered and future-proof justice. Thank you.
Agradecemos a Teresa.
Well, we greatly appreciate Teresa van der Lubbe for her collection of ideas that can help us provide better services without innovation necessarily impairing our independence. Innovation and independence are perfectly compatible. You are right about that. Congratulations on this excellent summary. According to this panel I'm reading now, we have 3 minutes left for answering questions. So if you're interested in asking anything of our formidable speakers or their experiences, be quick to do so. Perhaps we could ask if any of their good practices can be translated into our countries or adapted to our countries to move further along the path of an individual-centered justice system. Any takers for questions? Well, meanwhile, perhaps I will break the ice by sharing an experience that was very relevant in Spain. It's an experience of coordination of institutions and the legal system, particularly in the field of violence against women. since 2010, a need to join different sectors of society and politics was detected to struggle together in the field of domestic violence against women. At that time, an observatory was created in which different agents like the Ministry of Justice, the Professional Association of Lawyers, the Bar Association, local governance, and the judiciary power that sit together to assess the efficiency of protection measures for women facing gender violence. And I'm glad to report that since this observatory started working, which has now legal entity in our legislation, there has been an ongoing monitoring of this type of violence, and that monitoring provides a true picture of this criminal phenomenon in real time so that we can assess the most appropriate measures while enabling protection of the victims and preparing legal staff, law enforcement bodies to keep this social scourge under control. I believe this is one of the most successful experiences I have witnessed because it turned a human rights issue like domestic violence against women, which was considered as pertaining to the private sphere and therefore under the radar of the law, and turn it into a public human rights problem. The observatory constantly monitors the legal and judiciary measures being applied. So, if this comment has given anyone the time to rethink the possibility of asking, please shoot. If not, I cannot but thank you for your kind attention and highlight the importance of the cooperation between state powers, judiciary and executive, to support the rule of law, which is our true defense against a complicated landscape in which democracies are under siege. Thank you for your commitment and for your hard work, and I hope I will see you all very soon. Thank you.
Thank you very much. Everyone for this amazing panel on leadership, and that's the place where it all needs to come together. We've now come to the closing reflections. And one of my tasks was to kind of see what story emerged. But there's, of course, a big risk that I will spend about 5 hours coming up with great thoughts, and you won't get your dinner, and we won't get to listen to the people who opened this panel, the Deputy Secretary General and the State Minister. But let me just a few things that I've seen. One, I think it's quite clear for everybody that this idea of justice being the cornerstone of resilient societies and thriving economies, yeah, that's something we all agree on. And we kind of all have been saying all through the day that even though that's the case, it's not really working. Second thing is what keeps emerging a lot is We didn't talk a lot about it, and I think, Deputy Secretary General, you found the best words to say it. I don't even know what to call it, which is probably, you know, in Harry Potter they had the you-know-who. It's so big, it's so complex, we don't really know what it is, but we are in a time of crisis. Thirdly, the importance of trust as an issue, and I'm sure you'll say something about it, and people-centered justice as being part of a wider issue of trust and of government having to deliver. And then if you look at what we have, I think we all said, you know, there's actually also a lot of good news. There is the OECD recommendation referred to by many of you. I still think it is the best practice that is out there of what is needed to deal with this crisis. And we heard more, the Responsible Rule of Law report, there was the report on the SMEs. I mean, there's a lot of stuff out there, there's data out there. There were some great examples of working across systems out there. On AI, I guess we heard it is a huge possibility, but a huge disruptor, but a lot of stuff we still need to kind of understand. Data, I cannot say it enough, how important that is, as long as you have the right data. And then maybe just a few things then, what now, and where do we go? And what are the actions? And one of the key things I take away, but I'd be very interested in the reflections of the Deputy Secretary General and the State Minister on that, is I hear we need a lot of new stuff, as not as in necessarily new laws, but new ways of working, new skills, new ways of understanding how you budget and how you finance, new ways of monitoring and learning, change management. How do you, I think one of the speakers in the last panel said, you know, how do you keep the system going while at the same time changing it and adapting to these changes? Those are kind of the questions that I'm stuck with. And with that, I'd like to hand over to first you, Deputy Secretary General, and then after that, the State Minister will address us. Please, you have the floor.
Well, I don't know that I can answer any of those questions, but let me just say my brain is full, right? There has been such a rich level of discussion today, and I just want to thank you for that. Thank you for the depth, the realism, the ambition, for challenging us to see these issues through a new light, and for challenging us to think about it all as a collective community here. If yesterday's sort of dialogue gave us the big picture on how to shape justice systems that earn trust and deliver prosperity, then today, I believe, moved us into the how to redesign justice so that it is proactive, digitally enabled, economically enabling, and firmly people-centered. We've had one idea that has come through strongly across the sessions. Justice and the rule of law are not only about rights, they're about critical infrastructure. Infrastructure for competitiveness and infrastructure for resilience. And that's maybe part of the shift that we need our governments to think about. The rule of law is critical infrastructure. So let me highlight 3 points from today's agenda. First, our opening session on the future of justice underpinned that justice must function as a public service, a modern public service, which solves problems, is accessible, and is designed around people's and businesses' real journeys, not the institutional silos. Justice leaders need a deliberate strategy for AI. One of the most impactful sessions this morning, right? This strategy of AI, avoiding the hype, focusing on long-term responsible integration. We all need to start small, but think big. Begin with one AI-powered workflow. Test it carefully. Share lessons so that everybody can benefit. sharing practices, engaging with the sector to ensure that AI serves justice effectively. That means the future starts now. To shape the future together, we've got to bring leaders, advocates, and legal experts together now to define and build the justice system that we want for the next decade and beyond. Secondly, the sessions on AI and data-driven justice showed that digitalization can transform how justice is delivered, cutting the backlogs, improving inconsistency, enhancing access. But this only works if it is supported by strong data governance, by safeguards, and by accountability. AI and digital technologies are transforming how justice systems function and how people resolve their problems. From the AI-assisted triage and automated administrative processes to predictive decision-making, AI tools are streamlining processes, reducing backlogs, and enhancing efficiency for our justice systems. But as AI is continuing to evolve, the justice systems must be equipped to use it responsibly. Safeguarding rights, reducing inequalities, and reinforcing public trust are critical and will continue to be critical. We heard participants share how emerging technologies are being used to enhance service delivery, support legal aid provision, and make justice more efficient and accessible for vulnerable populations. For example, Spain. We heard about the Spanish initiatives that are showing how AI can make justice more people-centered by improving accessibility to people and efficacy in the delivery of justice services. Another example from the state of New Jersey. AI is helping public defenders manage their workloads in order to have more time to focus on clients, especially for those populations in more vulnerable situations. Imagine that, lawyers wanting more time to focus on clients instead of the paperwork, right? Being data-driven, building data-driven systems requires sound governance, including a skilled workforce and infrastructure. Clear management for risk is also key, and implementation across all the courts, moving from theory to practice to better serve people and businesses. Thirdly, our exchanges on justice for growth and competitiveness, and on safeguarding the rule of law. It reinforced that efficient, predictable, and independent justice systems are essential for investments, innovation, and SME growth. Legal certainty and trusted courts are part of a country's competitiveness package. Justice systems that understand the specific legal and administrative challenges that SMEs face can reduce costs, delays, and uncertainty. We heard Latvia that has streamlined the administrative processes, removed the unnecessary documentation, and introduced guidance services that provide clear examples and timely responses. We heard from Japan about their reforms, including the full digitalization of civil litigation with online filing, video hearings, digital case records, and statutory time limits for concluding the trials and issuing the judgments, thereby reducing the cost and having shortened the duration of the proceedings and enabled and enhanced predictability. All of this taken together has really helped me to at least believe that we have reconfirmed that people-centered, data-informed, and independent justice systems are indispensable for both trust and economic performance. So I have committed to giving our very hardworking OECD team the weekend off. I know this is shocking, but I'm going to let them have Saturday and Sunday. And then we're going to really take some time to reflect on all of the truly rich inputs that we've had from today. But looking forward, I think we can foresee 5 main priorities around where the OECD is going to continue to focus some of its justice work. The first, continuing to develop and refine practical tools to help countries implement this OECD recommendation on access to justice and people-centered justice systems. This is really the backbone and the core of our work. Secondly, to build a global knowledge infrastructure, which we're going to need all of you to help us continue to do and expand upon. But this global knowledge infrastructure for justice, bringing together people, data, evidence, case studies, good practices that can help to power some innovation, accountability, and reform, and to reinforce the global networks and the peer learning, including through our OECD Justice Roundtables. Thirdly, to strengthen monitoring, benchmarking, work on data and indicators so that countries can track results and understand what works. This is so critical. And this will culminate in the People-Centered Justice Indicators, as well as the State of People-Centered Justice Report. We do not make easy titles for our reports. We know this, but you get exactly what it is. And the whole point of this is to provide a global picture on the progress and the gaps and the promising approaches that all of you are trying. Fourth, to deepen our analysis to make a stronger case for investment in justice as a driver of sound business climate and competitiveness. I think this is really important in this particular moment in time, when democracy and the rule of law are under attack, to speak the language of how the rule of law can help deliver on the economic competitiveness issue. That's not to say that supporting democracy and the rule of law is not essentially important, and we will continue to do that too, as I hope all of you will. But if we're going to make headwinds in some of these global challenges right now, speaking the language of economics and why it matters to have the rule of law, to have a stable system that businesses and investment can rely on, can really help us break through, I believe, in this environment. And finally, we're going to continue to support countries directly through diagnostics, policy advice, reform design, and implementation to support their efforts to pivot towards people-centered justice. We look forward to working on all of these areas with all of the interested countries, civil society, other organizations, and to cooperate with all of you and beyond in this room, along with the Justice Action Coalition. So tomorrow, we have another busy day with technical roundtables. And these roundtables will be an opportunity to further explore many of the issues discussed today, but in a more depth manner. From redesigning justice services to measuring people-centered justice performance and implementing our OECD recommendation in practice, to strengthening access to justice for SMEs and investment in justice, and to learning from Spain's digital justice reforms. These conversations will help convert today's priorities into concrete steps for all of our justice stakeholders. To conclude, over these past 2 days, you all have shown that justice is not a peripheral concern. It is central to how our economies grow, how our democracies function, and how our societies hold together. On behalf of the OECD, I truly want to thank you for your engagement, your partnership, and your expertise. I have learned a lot, and I thank all of you for that. And we look forward to continuing this work with you tomorrow, but also beyond. So thank you all very much. I hope you enjoy your evening, and I look forward to seeing you at the cocktail later this evening. Thank you.
State Minister, may I now invite you to the floor.
Buenas tardes.
Good evening. I share Mary Beth's dilemma. Way too many things to ponder upon, right? I believe that as days go by, all of us attending this place will continue to digest all the things we've been learning here today to pile it up on top of things we already knew to generate a new mind map of where we stand and where we want to go. Certainly, we started off this morning with AI and the way new technologies are transforming justice systems and the way people resolve their conflicts. We've seen all sorts of tools. We've heard all sorts of questions about the implementation of AI and how to address them in the present context, and reinforcing the protection of human rights and political organization of the state in agreement to the principles of the social state, democracy, and the rule of law. And we've come to the conclusion that in the face of constant evolution, innovation is no longer an option. It's a need, it's a must. We need to be at the spearhead. And that's a brave attitude. But that innovation must be tackled jointly. Everyone here who believes in this context of protecting the principles of the rule of law and democracy, what Mary Beth called the global knowledge infrastructure, right? Sharing that knowledge is vital. We also spoke of data-oriented justice systems, a change in mindset that involves going from the document-based traditional scheme towards a data-based system, because we're constantly exchanging real-time information in this society, which is now a must for our day-to-day activities. In the Middle Ages and before, we see copies of the Roman classics, Greek classics, written by hand and copied by hand in important ports of the Mediterranean, Genoa, Alexandria, Istanbul, Barcelona. But it would take years to copy, say, the Odyssey. But now data exchange happens instantly. And we need it to be instant so that we can move ahead and continue to progress and reinforce the principles of the rule of law. All public servants need that immediate exchange, and that is why we need interoperable data-based systems. We need information to travel from one place to the other at light speed. Third table, third idea. The relevance of fostering competitiveness among companies and economic progress. Democracy is good for our wallets, for our pockets. Authoritarianism is expensive. And I believe this is a fundamental idea. We have to set down the foundations of a legal certainty that will provide credit flows and investment flows for democracy to lead to prosperity, which is another idea that Mary Beth conveyed beautifully. And finally, a session on the importance of safeguarding the rule of law through the loyal cooperation among different powers of the state. It is vital to protect judiciary independence and an institutional connection among state powers, maintaining the checks and balances existing in each country depending on their own democratic history. But loyal cooperation among state powers will allow each of them to further strengthen the rule of law. As a host for this experience, I hope that all of these ideas will find fertile ground in your minds so that you can bring them to your countries of origin and come up with new products and ideas that we can share in our next OECD table in Istanbul and via our regular communication channels. I mean, face-to-face meetings are vital, but meanwhile, we need to remain in contact thanks to the modern means in our hands. I do remind you that everyone is invited to the cocktail at 8 p.m. And today we also have a video on our works of the day.
The second day of the 10th OECD Global Roundtable on Equal Access to Justice focused on digital transformation. International experts, institutions, and multilateral organizations presented initiatives demonstrating how technology can strengthen judicial systems and make them more inclusive. Discussions addressed key themes such as the strategic use of data, the application of artificial intelligence in the justice sector, and the role of digitalization in streamlining procedures and ensuring equal access. The debate also highlighted the importance of international cooperation and the ethical use of technology as essential tools for protecting the rule of law and reinforcing citizens' trust in public institutions. A day that reaffirmed a clear message: the justice of the future will be innovative, open to change, and centered on the needs of society.
Once again, thank you very much. Thank you, Sam, for magnificent mastering of this day, and hope to see you, all of you, tomorrow. Goodbye.